Hello students, welcome back to the Analyst for 18 July 2024, where we will be discussing 9 most important articles from the Hindu and the Indian Express. The very first article is regarding the political representation of women in India. In the next article, we'll be looking into the various provisions of the Prevention of Money Laundering Act and the recent Supreme Court observations on the same. In the next article, we'll be looking into the various issues regarding the governors in various states and with the respective state governments. In the next article, we'll be looking into a report, a survey on the unorganized and informal sector of the country. And in the last article, we'll be looking into the reasons behind the heavy rainfall in the country as of now. Finally, we'll be wrapping up the discussion with Prelims Snippets, where we'll be discussing 4 more important articles from Prelims point of view. So stay tuned. Hello students, welcome to the very first article. Here we'll be looking into the political representation of women in the country. And when we talk about the political representation, it is actually the most important representation when it comes to the inclusion of a particular class of people, a particular section of the population in the active politics of the day. And we have to understand that in the active politics of the day, we definitely have to include the diverse spectrum of individuals, the citizens of our country. And that is where the representation of women becomes very, very important, because according to recent articles, according to also the recent general elections of 2024, we found that there was not a very significant improvement when it comes to the participation of women in political life, particularly being MPs or MLAs in the country. And this is where we have to understand this topic is highly important, highly significant for our UPSC prelims, where we have the topic of Indian polity and governance, for our GS1, where we have the role of women and women's organization, and finally for GS2, where we have to look into the functioning of the parliament and the state legislative assemblies. So here, starting with the very article, we have to understand the historical significance of the political representation of women. We have to understand obviously that the representation of women in the past was not as good as it is right now. Even we understand the situation right now is not good, but the situation back then was not at all palpable. Now, because you have to understand the historical milestones in universal suffrage, that is granting or say giving the access of political rights, say right to vote, right of say fighting elections, being candidates for women. Right, it actually started for the very first time officially in New Zealand. It started in 1893. These small trends, these small aspects are very important. Particularly, this piece of information can be very important in ASUSE related to women empowerment, and also in answers of ethics, and also say in answers of GS1 and GS2, where we have to show the historical evolution of participation of women. So it started with New Zealand in 1893. Right, which was the very first country to grant universal women's suffrage. Right, that means the rights of women, right, regarding political rights was not constrained to their status, to their participation in society and so on. So they are universal rights. Now UK followed in 1928. If you can see, this comes more than 30 years from New Zealand. US also followed after say its 19th amendment to the constitution in 1920. Then and finally India granted all women the right to vote in 1952. And here we have to understand the recent progress in global democracies when it comes to the participation, apart from the say historical evolution that we understand right now. The UK, which recently saw the polls, it recorded 40% women MPs, which is the highest in their own House of Commons. In South Africa, they around have 45% of women representation in the say their parliament. And finally the US House of Representatives, they are seeing a figure of almost 30% or 29% of the women members. And if we look at the comparison of India with the BRICS and other nations, the BRICS countries, right, and the other nations such as Sweden, Norway, China and so on, we find that countries like Sweden, Norway, China, Germany, right, Russia, so they have a high representation of women with reference to India. If we compare India, right, so participation of women in say the legislative bodies, they only range in India from say around 5% to around say 15 to 20%. So it is actually very, very low. As of now, as we look into the current Lok Sabha elections, only around 14.5 to around 15% are actually women MPs at the say Indian Parliament. So this is where we have to understand only around 14% are women MPs at the Lok Sabha. Now this is a very, very important aspect, because we have to understand the various data with reference to the low representation of Indian in the Indian legislative bodies. Now we have to understand women MPs in the Lok Sabha was between 5% and 10% until 2004. It increased marginally to 12% in 2014, and currently it is at 14%, as I told you, right? According to the 18th Lok Sabha data from the Election Commission of India and also the Indian Parliament data, we find that it is at 14%. And when we look at the state legislative assemblies, we have at an average only of 9% women representatives, and this we have to understand that less than 10% of the overall state legislative assemblies in the country of both states and UTs, right? They only have less than 10% of women MLAs at their assemblies, right? It is Tripura, which is the only state in the country which is reaching 15% mark. That means 15% of the representatives that are actually coming from the women community, right? Also, according to the Inter-Parliamentary Union Report of 2024, we find that India is ranked at 143rd rank, right? And also, if you look at the Global Gender Gap Report of 2022, India ranked 135 out of the overall nations, right? Now we have to understand this is actually showing dismal figure of the representation of the women in the country, and that is where you have to understand that from say around 5% when India became independent, right, to around 14.4% to around say 14% right now is not a very big achievement. So definitely we have some issues, and we have to say look into these issues and solve the issues of representation, particularly because we have to understand that the representation of women is a very sensitive issue when it comes to the political side, because of say the historical stereotypical role of say the Indian societal mindset towards women, right? Be it on gender lines, be it on caste lines, be it on religious line, it has been seen that women as a community has actually suffered a lot when it comes to the political stage, right, due to very family aspirations, due to various other societal pressures. So it has not been possible still now for women to reach that level. When it comes to representation in huge numbers, at least say around 30, 35%, 40% of representation will be assuring that at least their voices or at least their policies are being taken care of. So this is where we have to understand the need for for effective representation, not only say mere numerical representation of 10%, 15% and so on. So mere symbolic numeric representation has no value until and unless we have some statutory or some constitutional provisions which effectively explicitly give some say status, give some representation for women at the political level, because until and unless they're reaching a level in which they can actually make decisions, to that extent the other kinds of provisions are not actually valid. So that is why in our constitution, in the 73rd and the 74th amendments, we have had some provisions where we have reserved the 1/3 of the seats for women at the Gram Sabhas, at the municipal local bodies, right? So we have for the local body elections, we have 1/3 of the reservations for the women community. And also the latest landmark bill or act, if you can say right now, the Women Reservation Act 2023 was actually in abeyance for a long period of time. It was introduced almost 10-15 years back, but it was in 2023 only when it was passed. It is famously known as the Nari Shakti Vandan Adhiniyam. So it is seeking to reserve 33% of the seats for the Lok Sabha and the state legislative assemblies for the women, right? It will be also introducing 3 articles, Article 330A, 332A and also 334A, where Article 330A and 332A, they will be establishing reservations in Lok Sabha and the state legislative assemblies. So it is to be noted, it is not in the Rajya Sabha, right? And also, according to Article 334A, we have to understand this is actually talking about the sunset provisions that for 15 years after the enactment, this reservation will be continued up till say subject to further renewal. So it will be having a provision of 15 years as a deadline, but after 15 years, the Parliament can again extend it forward, right? And also, there will be horizontal representation of women. That means that 1/3 of the seats in Lok Sabha, state legislative assemblies are already reserved for the various communities, right? For example, SCs and STs, right? So out of this also, there will be 1/3 of reservation for the women community, right? So this is where we have to understand about the horizontal representation of women that will be applicable also. Now this will be ensuring that in SCs, in STs, so there will be also women representatives coming from these communities also. There will be also rotation of seats after every delimitation according to the provision of the act, because we have to understand there must be not a constituency or not a seat, Lok Sabha seat, or say any other say seat of the state legislative assembly also, which will be permanently fixed for the women, because these seats must be changing, right? For example, there are 10 constituencies in the state, for example, right? For example, constituency 1 and constituency 2 and constituency 3, right? Or say constituency 4. So out of 10, 1, 2, 3, 4 constituencies are reserved for women. So it does not mean that the other 6 constituencies will never have some women representatives. So time and again, after every delimitation exercises, this provision will be taking into consideration. And finally, it will be implemented, we have to understand, it will be implemented only at the earliest after the 2021 census is taking place and a delimitation is done. So this is the only drawback as of now, that despite being an act as of now, it is not under implementation till a census is being conducted. The 2021 census is not yet conducted. So this is where we have to understand, this is the area where this act will be requiring some time to actually come into force. And we have to understand there are many debates, say pros and cons of the representation. Obviously the pros we have discussed. Now there are cons, that obviously this reservation will be seeing a particular vote bank for women. So there can be some political parties which can be mobilizing women on the various other aspects related to reservation. So we have to understand reservation is never a magic pill in this particular aspect, according to some critics, according to some experts, according to some political scientists. They say that gradually this reservation must be weaned off, say after 40 years, after 50 years. This cannot be the permanent aspect, because it is seen that most often reservation breeds vote bank politics. Also reservation in this particular aspect, according to some legal experts, this will be also presenting some constitutional challenges for the Supreme Court, right? So this is yet to be seen as to how the implementation will be on the ground. And finally, the third criticism is that implementation is not yet done. So this implementation will be taking place say after 2029, when the next 19th Lok Sabha election will be conducted, and before that maybe a delimitation exercise will be conducted. So until that we can only have this thing on the paper as of now. So definitely we need some more holistic women representation in the country as of now. So obviously we know that it is her time. We know that it is our time in 21st century. We have to understand the inclusion of the various classes of the population in the various aspects of society, governance, economy is highly required. And it is also highly progressive to be understood. And that is why we have to understand, apart from only reservation, there must be other changes also. We must be following a very excellent role model. You can actually quote this into mains answer. Right? An excellent role model in Tamil Nadu, in a political party of Tamil Nadu, the political party name is Nam Tamilar Kachi, which has voluntarily reserved 50% of all the party seats, all the seats that they would contest in the assemblies or the Lok Sabha elections. They have reserved 50% voluntarily by themselves for the women. This is actually also practiced in France, South Korea, Nepal, and some of the other nations. So this is actually a very good way of reforming the internal political party dynamics. So political parties themselves should be promoting, right, say giving party tickets at least 50% or at least say 40% to the women representatives. So it should be adopted almost like model code of conduct, which was actually initially a voluntary code of practices or say a model code of conduct followed by the political parties. Right, so it can be done on a voluntary basis. So Election Commission of India in this matter can be spreading the awareness between the parties. It is also imperative that we must be conducting the census 2021 as soon as possible. It has been already been delayed. It has already have been delayed for more than 2 to 3 to 4 years right now. Right. Also, 2013 Committee on the Status of Women, they have also talked about increasing the reservation to 50% at the local bodies. So we must be again trying to increase the 1/3 of reservation to 50% of the same. This is according to 2013 committee recommendations. And finally, the Geeta Mukherjee committee also talked about in 1996 the aspect of, or say, inclusion of the OBCs, and also the looking into the dynamics of how OBCs and women representation and the quota can be looked into. So these are all the important aspects that you should be definitely be understanding and using them in your mains answers. And for you all, I have another practice question as always. The representation of women in political life is crucial to functional democracy. Explain in the light of India's Women Reservation Act 2023. I want from all of you, say your own unique points, your own unique ideals, your own unique ideas and viewpoints on this particular matter, on this answer in the comments. So let me know what do you think, what can be done more, what can be actually be tried to implement to increase the participation, holistic participation of women in public policy life. In the next article, we'll be looking into this editorial in the Hindu named Arrest and Liberty, which is actually talking into the two important crucial reservations and observations done by the Supreme Court on the functioning and the performing of the Prevention of Money Laundering Act in the country. Supreme Court has actually flagged some of the important issues which will be looking into, or say, hurting personal liberty in the country. And this is actually related to the PMLA Act. And here, this is a very important topic for UPSC Prelims, Indian Polity and Governance, and for GS2, for the various government policies and interventions for development in the various sectors of the country. And here, you have to understand, firstly, the origin of the PMLA Act in the very beginning, right? So it was actually originated in the 1970s in the US, right? Because from 1970s to 1980s, it was seen that in the US and some of the Western nations, the issue of drugs trafficking, abuse in the youth, that was growing over a period of time. And that is when the international community tried to actually take some measures to combat this drug menace in the entire world. So this was actually followed by humongous volume of black money also, which was pumped into the drug trade all around the world. And the economy, the black economy, which was generated via this drug economy, was actually plaguing the entire nation. So that is when the entire world stood united, and particularly the United Nations Convention Against Illicit Traffic in the Narcotic Drugs and Psychotropic Substances Convention of 1988 was actually taken into consideration. So where countries were actually urged to take stringent steps against drug peddling, money laundering activities, which is actually a process of how black money or illegitimate money is actually converted into white money or legitimate money. It was urged for the various countries to take some stringent steps. And in July 1989, the G7 formed the Financial Action Task Force, the FATF, which was also popularly known, right? And then also in 2000, we understand that the United Nations Convention on the Transnational Organized Crime ratified the first anti-money laundering treaty. Before that, the United Nations General Assembly, they signed this political declaration and global program of action. And that is why, due to these various global actions, right, we understand in 2002, we understand that if there will be any international convention or act, India must be also try to adopt that in the domestic arena. So that is when the Indian Parliament enacted the PMLA Act to actually combat black money coming from drug trafficking and illegal trade from underground activities, right? So this is where we have to understand is the origin of our own PMLA Act. And here, Indian Parliament enacted this PMLA Act. Few offences in the Indian Penal Code and the Narcotic Drugs and Psychotropic Substances Act were actually codified under the same. And here, when we talk about the PMLA Act in the country 2022, it firstly we have to understand the provisions of the thing is firstly trying to defining the money laundering activity comprehensively, so that for all law and regulation purposes, a particular definition of money laundering is there in the country. And then it is having the following objectives. Firstly, to prevent money laundering coming from the drug activities. It is also talking about the confiscation of any property derived from money laundering. There would be a fine and also a combination of fine and minimum of 3 years of imprisonment of any individuals caught in the act. And also this fine and imprisonment can extend to 7 years. Right? And here, there can be also an appointing of an adjudicating authority and appellate tribunal, and also setting up a special sessions court under the PMLA Act. Now, the role of the ED is very important under PMLA, because we have to understand the Enforcement Directorate, which is actually under the Revenue Department, Ministry of Finance. It is actually tasked for or with the investigating the various offences committed under the PMLA. Apart from say the PMLA Act and the various investigation under the same, the ED has also the authority under Foreign Exchange Management Act to conduct investigations into various foreign exchange laws, violations and so on, right? It is also looking into the Fugitive Economic Offenders Act to look into the various people who have committed economic offences in the country and they are leaving the country, right? Two examples from your side can be given in the comment section below also, right? And here we also have the Foreign Exchange Regulation Act, which is right now repealed. So ED also had the authority under this particular act. And also we have the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act of 1974, where the various aspects of preventive detention can be done by the ED with reference to any convention of the FEMA Act, right? So this is where we have to understand ED is a very, very important investigative authority here. Now, after ED, we have an final authority which is looking into the various information gathering related to economic offences under drug trafficking and various PMLA related offences, which is known as the Financial Intelligence Unit, which is also under the Department of Revenue, which is actually tasked with collecting intelligence or information related economic offences. And finally, for all the other offences such as schedule offences, right, it is actually the main task of dealing with it is actually with the local police, CBI, Customs Department, CB, or any other investigative agency if there is a particular jurisdiction of their own side. So the offences listed under the PMLA, the ED will be having the investigation authority, and for the other instances, the police, the CB, the CBI, they can also investigate if they are actually given the investigation charge. Now we have to come to the main issues here. Now the main issues regarding ED and regarding PMLA is about encroaching the individual liberty of the citizens. It has been seen, it has been alleged, it has been debated on the national media that the ED is being used for many political activities, for many cases where sometimes the cases are not even related to PMLA. So it has been seen in the recent circles as a tool to combat or say to fulfill political aspirations according to various allegations. And this is where this aspect of bail conditions under ED, under PMLA Act, under section 45 of the PMLA Act becomes very, very important, because we have to understand once the investigation begins and when the investigation done by the ED continues and the investigations or say the authorities involved in it try to prosecute, try to charge one individual, try to charge a group and with the offences under the PMLA. So what are the conditions for bail? What are the conditions for justice? What is the condition for the say various amounts of fundamental right violations and the same? So here it is understood that the bail conditions or say the condition when after conviction the accused individual under say PMLA, they can actually try to appeal to the court for granting them bail conditions. So this is actually satisfied on the twin conditions for bail. The court must be satisfied, and via the court obviously we mean the judge. The judge must be satisfied, and here the court can be say the lower court, high court, supreme court, right? The court in nevertheless must be satisfied that the person charged under this particular PMLA offences, when that person is actually say filing for bail. So firstly the person must be having some reasonable grounds for innocence, or where the persons must be proving their prima facie innocence, that is their innocence purely, they do not have any connections with the crime, that they are falsely accused or in this kind of conditions, or they the individuals who are seeking bail, they do not pose any future risk for the country. So firstly the judge must be satisfied of these two things, and it is very difficult to understand. It is also apparent that a judge can never be sure of a particular say person's innocence or a particular say person's say future offences guarantee, right? The main aspect here, it is left to the satisfaction of judge, and indirectly it is also made more strict, is because the main primary aim of this stringent bail condition is to ensure stringent control over the release of accused individuals, because it can be understood while we have looked into allegations, but on the reality there can be also some serious cases where the person can be a powerful individual with lots of money, power and so on. So that person can use sophisticated legal devices, good amount of network of lawyers to seek bail. So this is where we have to understand the bail conditions must be stringent for the serious offences, and this is actually looking into or say reflecting the serious nature of the crime, and also this will be preventing any potential impact on the economic aspect of the country, on the economic stability of the country also, because these crimes are related to the economic offenses or drug trafficking, money laundering, black marketing, black money, underground economy. So any potential outfall of this particular thing after bail conditions, they must be trying to address the potential impacts, and that is why the bail has been made very, very strict. But we have to understand there have been many petitions at the Supreme Court regarding PMLA Act and the stringent bail conditions, and in the Nikesh Tarachand Shah case of 2018, Supreme Court actually told that this particular bill provision is unconstitutional. But government again did some changes to the PMLA Act, and finally in 2022, in the Vijay Madanlal case at the Supreme Court, the ED's power under PMLA Act was actually sanctified by the Supreme Court, where the offences of money laundering is of heinous nature and it can be contributed to terrorism, the Supreme Court remarked, right? The section 3, the section 24, the section 5 will be staying. That means they are not unconstitutional. So it can be seen that this particular judgment, the Vijay Madanlal judgment of 2022, is actually overturning the judgment of Nikesh Tarachand case of 2018. So in this particular case, it was actually seen that the stringent conditions of the PMLA Act is actually required to actually combat the economic offences and the money laundering aspect here, right? And now we have to look into this particular aspect when we look into the various imperatives of safeguarding the nation from economic offences, money laundering aspect, right? So this is where this particular judgment was significant. But as of now, there was also this case about the Delhi Chief Minister being granted bail, right, by the Supreme Court here. And in this case, which is actually going on, and right now the case and some provisions of the case, some aspects of the case, some legal scrutiny of the case has been actually referred to a larger bench in which the Supreme Court judges have actually came up with two observations. Note that the issue is still sub judice, nothing is concluding or say final yet, but you are getting two important crucial observations which you can state in your mains answers to make your points very, very solid. Firstly, the Supreme Court is telling that the necessity for arrest under PMLA conditions or PMLA provisions raises some eyebrows. How? Because according to section 19 of PMLA, the investigative authorities of the ED, they have a reason to believe of a particular say accused, of a particular accused individuals if they will be arrested or not. But the Supreme Court actually told that is reason to believe as same as a necessity to arrest a person. The officials, if they can actually create their own reasons, does that reflect that there is a necessity of arrest? Necessity is always contingent on the grounds of actual say offences, right? When a person is actually arrested, if that person's economic offences, criminal activities necessitate that they should be in prison, they should be punished. But there have been many cases, that is why it has been, we have also understood that there are many political reasons, there are many allegations of the ED being used against the very state government, state MLAs, MPs and so on. So sometimes it has been seen the reason is not as the same as necessity. So that is why SC has asked that whether proving necessity of arrest is required under section 19 or not, right? So this is a question where we have to understand, and here we have to Supreme Court has told that officer's decision or officer's reason to believe is not a blanket immunity from any Supreme Court or any High Court or any court in the country. So officer's decision will be subjected to judicial review. The first important observation. Second, that staying bail conditions, staying bail orders of particular politicians or particular individuals seeking bail, it has been seen that the government's public prosecutor, government's own lawyer, which is actually trying to put the accused person in PMLA and in jail. So they take a vigorous and aggressive stance against the bail conditions. So when an accused individual is asking for bail, that bail condition is vigorously being nullified and vigorously defended in court, right? by the prosecution from the government side. So we can understand this is a general tendency from the government's mindset that maybe the persons will not be granted bail so easily. So getting a bail and also the twin conditions for bail, as we have seen in the previous slide, makes it very, very difficult for individuals convicted under PMLA to actually get bail. Even innocent citizens, innocent say accused individuals, they have this difficulty because the government's defense, the ED's defense, is actually very, very strong, and they have a routine practice of staying bail orders. So now the Supreme Court is actually appealing to all of the judges, all of the courts, that the bail must be actually seen as a routine activity. Staying a bail or not giving a bail should be the rarest of rarest occurrences, because the provision of bail is actually an intrinsic aspect of a person's liberty, right to liberty and life under Article 21. It is actually going against the fundamental rights, again the human rights. If a person is not even given the opportunity to represent bail or give in the bail based on, say, this kind of conditions. So this is where we have to understand that only in exceptional cases the bail can be stayed. Otherwise, we have to make this a routine procedure. Right? So, on the same lines, I have another question for you. The Prevention of Money Laundering Act is a double-edged sword. Do you agree? Explain using Supreme Court cases. Now, we have discussed a lot of things here. And again, in the comment section, you let me know whether you actually agree with the Supreme Court on this matter, whether there can be some aspects of the PMLA that can be amended even more further. So, for your mains, please do incorporate these points, and for your mains, also do practice such questions which are highly important, and also since these are in the news, probability of being asked such topics is actually very, very high. In the next one, we'll be looking into a very perennial issue in Indian polity, in Indian federalism aspect, when we talk about the rift and tussle between the state governments and the governors. Now, serious issues are resulting in the administrative and the legislative bottlenecks and functions in West Bengal due to clashes between the government, the state government and the governor. It's a very important aspect of UPSC prelims, Indian polity and governance in GS2, where we have to look into the issues and challenges pertaining to the federal structure of the country. Now, starting head on, firstly, we'll be looking into some of the constitutional provisions when we talk about the important role of governor into the daily functioning of the state governments. Firstly, the Article 153 states that there should be a governor for each state, right? And also, Article 163 of the Constitution says that there shall be a council of ministers with the chief minister at the head to aid and advise the governor in the exercise of his powers, except in so far he is required to exercise some discretion. And here we have to understand that, in some cases, in constitutional cases, in some general cases, the governor is having some amount of discretion. We'll be looking into some of the discretion aspects, but we have to understand that this discretion power is not absolute. And it is also in this article stated that there shall be a council of ministers to actually aid and advise, and it has been stated that the council of ministers is actually the most important aspect when it comes to the day-to-day functioning. Here, right? So we have to understand governor is just a titular head of the state. In Article 164, the chief minister shall be appointed by the governor, and the other ministers shall be appointed by the governor on the advice of the chief minister. And the ministers should be holding office under the pleasure of the governor. It does not mean that the governor can be removing any time. It is the chief minister, we have to understand, which will be aiding and advising the council of, the governor on the same. Right, so it is very important to understand the role of the chief minister and the council minister vis-a-vis the governor here. In the next provision of Article 174, the governor can also summon, prorogue, dissolve the legislative assembly by convention. The governor generally does this on the advice of the council of ministers, while they actually enjoy the assembly, the confidence of the assembly, right? And here Article 200 states that every bill passed in an assembly has to be sent to the governor, after which the governor has 4 options: to assent to the bill, to withhold assent to the bill, to reserve the bill for the consideration of the president, and finally to return the bill back to the legislature, asking it to reconsider. Right, and here we can look at the 2 important discretion that is available with the governor: constitutional and the situational. Constitutional discretion can be in the cases of when when they have to reserve the bill for the consideration of the president. This is actually a provision of the Constitution under Article 200, when he has to recommend for the president's rule in the state, right? and when given additional charge of the administrator of the union territory. So this is actually the constitutional discretion. Situational discretion is when for appointing chief minister after no party get majority, or when the incumbent chief minister dies in office. So in that case, the discretion is there, which is situational, which is not stated in the constitution anywhere, right? Council of ministers on an ability to prove confidence in the legislative assembly. So this is also a situational one. And finally, when he dissolves the assembly when it loses its majority. So this is also situational discretion. It has been seen on many instances in the last 4 or 5 years that governors has been misusing this constitutional and mostly the situational discretion to actually topple some state governments, right? So these are actually some allegations. There are actually some issues which the governors are actually practicing according to various experts, according to various allegations, that is hurting the Indian federal structure. Firstly, the clash of neutrality, because we have to understand the governor is a constitutional authority, right? That constitutional authority should not be partisan in any aspect. That particular person must be neutral. And there have been many allegations where the Raj Bhavans, which is actually the seat of the governor in various states, have been converted into the office of the political parties, right? Because due to, say, the security of tenure of 5 years, and also the governors are appointed by the president, we have to understand the main authority it has been alleged, the main authority is with the central government rather than the state government, because at no point in the appointment structure of the governor, the state administration, the state council ministers, the state chief ministers are being consulted, right? Next, the use of Article 356. It has been also understood that, according to the article, the governor is required to send a report, and also it has been seen that using this article, there have been many dismissal of the elected state legislative assemblies by using the precedence rule, which can be as easily as being inducted by actually sending, say, report. And around 120 times it has been implemented, and it started in India as soon as it became a constitutional democracy in 1951. So this practice is even continuing still now. Also, according to subsection case of 1974, the governor cannot exercise the discretionary powers while withholding any assent to the bill or returning a bill to the state legislature. That means there is no absolute power of, say, constitutional authority of the governor to do this, right? And we have to understand that the governors often ignore the advice of the state cabinet, right, by not passing the bills, by recommending the bills for the president assent, right? And also constitution does not lay down any time limit for the assent of the bills. So whatever issues we are discussing here, all of the issues, please do quote in your mains answers, and in the suggestions part, in the way forward part, try to give recommendation as to how these issues can be solved. Also, in the Vajiram Ravi case of 2016, it has been seen that Article 163 is not a general discretion. What was 163? 163, in the Article 163, that there will be a council of ministers which will be aiding and advising the governor in the exercise of the functions, where there should be some discretion, where except there is this kind of exception. But again, the Vajiram Ravi case, they told, the Supreme Court told that it is not a general discretion that should be used, right? It should be understood that the aid and advice of the chief minister is of the utmost important, because they actually have come from the elections, after contesting the elections, after taking the people's representatives, electoral promise to fulfill, at the legislature. So this is where they must be also, the governors must be respecting the electorate decisions. And finally, it has been also alleged that the governors have been interfering with the confidence of the state legislative assemblies, but it was alleged in the assemblies of Maharashtra and Madhya Pradesh governors, even in the case of Rajasthan. There have been many allegations where the governors' actions ultimately led to the collapse of the majority of the various political parties there. So that is where we have to take some constructive actions. Firstly, according to Supreme Court, we have to understand this statement is very, very important in the Vajiram Ravi case. The area for exercise of the governor's discretion is limited. Even in his limited area, his choice of action should not be arbitrary or fanciful. It must be a choice dictated by reason, actuated by good faith, and tempered by caution. What a beautiful statement by the Supreme Court. And you can definitely be using this in your mains answers. Try to beautify your answers with such statements, right? Also, we can understand that there are some suggestions where the chief ministers must be consulted before the appointment of a particular governor, so as to actually talk about the inclusive federalism in the country, where the chief ministers, the political representatives, they have actually some say in the appointment of the governors. And also there are some suggestions which talk about the governors say being removed by the impeachment, by the same fashion of impeachment by the state legislative assembly, as it is done in the case of president by the Indian Parliament. Also, according to Sarkaria Commission recommendation of 1987, the governor must discharge functions as per the advice of the ministers. Very, very important. So, it is the advice of the ministers, council minister, which is important, not the direction from the center, right? Also, the discretion must be used in the rarest of the cases, the constitutional and the general discretions, right? So, it is actually talking about the strength of character, the moral caliber of the governor to actually remain neutral in all of the matters. Also, the president's withholding assent, we have to understand when it comes to using this term. The reasons must be communicated to the state government when the governor is reserving the bill for the president's assent. The reasons must be communicated in writing to the state governments. Note that we are looking into the various way forward suggestions what can be done. The next suggestion is actually coming from the Pucci Commission of 2010, where the governor should be actually taking a decision within 6 months, or there should be a time limit into the various bills and aspects of the same. And finally, our governor must be most importantly a friend, philosopher and guide for the state government, because it is only through participative government, participative federalism, the country can move forward. It must be, the governors must be actually upholding the integrity and the unity of the country in the most critical times. The federalism is a basic structure of the constitution, they have to understand. And this is where they have to understand they are actually taking the weight of the entire basic structure of the entire federalism on their shoulders if they perform a good job. And they must be respecting the elected governance at the end of the day, because the chief minister, the council of ministers, they are elected. The governors are not elected, they are selected. So it is obviously always the elected members that must be listened to because they represent the voice of the people, right? Now in this, I have a 2014 PYQ, Prelims PYQ for you all to actually let me know in the comments below. So give the answer to this MCQ in the comments below. In the next article, we will be looking into annual survey of unincorporated sector enterprises. And it has been seen over the last 7 years, many unincorporated units have shut down. 16.45 lakh jobs have been lost in the non-farm informal economy, and data from the annual survey of unincorporated enterprises show exactly this and many other things according to this editorial. Very, very important portion for your economic and social development and for your mains Indian economy. The various issues related to planning, employment and so on. So this is where we will be getting some various important crucial data that you can use in your mains answers. Right, when we talk about this report, this survey is looking into the unorganized or informal sector of the country, where we have the various MSMEs, the micro, small and medium enterprises, and the various household units, where in the MSMEs there can be some people who work on wages, which work on salaries, but in the household units, the own household members, they work in the various informal sector, right? Then for this report, they have taken 3 sectors: manufacturing, trade and other services. And there are some industries, some factories which are not covered. Firstly, the factories which are or say the units, establishments, manufacturing activities which are covered under Factories Act of 1948, they are not covered. The industries, factories which are covered under Annual Survey of Industries, they are not covered under this survey. Central Electricity Authority and the various units under this act, they are not covered, and any limited diameter partnership establishments, they are also not covered. Except these, all the other informal sectors, they are actually taken into consideration. Now if you can look here, if you can look into the various data, if you look at the various data of the informal sector with reference to manufacturing sector, we understand that right now there are around 1.78 units, say 1.78 crore units which are in the informal sector, and 3.606 workers in the manufacturing sector. In the trade sector, there are around presently 2.25 units, 2.25 crore units and 3.9 crore workers. In the services sector, there are around 2.46 units, 2.46 crore units, and around 4 crore workers employed here. So understand, here very simply we can understand that there are a lot of people actually who are employed in the informal economy, right? And also if we can look at the state-wise informal sector enterprises, right, it is actually UP, West Bengal, Maharashtra, Tamil Nadu, Bihar, which are actually the top 5 states with the highest amount of informal sector, right? And here, what the headline trend generally show in the years from 2015, 2020 to 2023, that firstly we have a deterioration in the quality of employment. When we talk about the quality of employment, we mean the nature of jobs. If the jobs are having particular job security or not, social security benefits or not. Firstly, we saw that informal sector registered a decrease in employment. Firstly, we find that in the formal sector, people are not having jobs. In the informal sector also, there is a decline of job in the last, say, 7-8 years. Secondly, also the own account enterprises or the household enterprises, they saw an increase. That means right now people are actually seeking to open their own employment sector in their own household operations. This is not good for the country. Why? Because firstly, there's a decrease in the informal economy, firstly. Secondly, people are actually not getting job in the formal or informal sector right now, and they're actually trying to opening their own enterprises, own sets of business, and this is generally by taking many loans, by taking many liabilities, and this is where there is a cause of concern, right? Second, the household units are more preferred rather than hired worker units because of the poor financial capacity of the informal sector, and also this is reflecting the PLFS 2022-23 report with reference to the workers participating in the agricultural sector, where in the agricultural sector, it has actually increased, the workers participating in here in the agricultural sector to 45.8% from 42% in 2017-18. So it has been understood that due to no job in the formal sector, due to no job in the informal sector, people are actually moving back into agriculture. So this is a very worrying trend for the economy, right? And finally, if you look at the gross value added for enterprises, it actually increased to around 2.3 lakh in 2022-23 from 1.8 lakh. But this is the nominal increase. This is the nominal increase. Actually, the real GVA is lower than the pre-pandemic level. So it is an indication that the pandemic actually impacted the informal economy by huge margins, especially after the lockdowns and the shutdowns of the economy for consecutive 3-4 times. So this is where we have to understand the main aspects or the main suggestions or the way forward that the government must be looking forward. Firstly, the Swadeshi Jagran Manch is actually protesting against the various labor exploitation in the country, and they are proposing a robot tax in budget 2024 due to the various displacement of various labor due to say artificial intelligence, due to advanced robotic machineries and advanced equipments in the factories, which is leading to job loss. They are also demanding to convey the long pending Indian Labour Conference by actually bringing all the trade unions in the country under one umbrella and talking and looking into the various issues they are facing. We must be also looking into various technological innovations where the labor can be actually augmented in the various industries by using technology. So here there is actually an importance of scaling as per written. Next, the agricultural production, as we can see right now, according to the PLFS survey and also according to this report, since the participation of people in agriculture has slightly increased by around 5-6% in the last, say, 4 or 5 years, right? This actually makes it very important right now for the country to actually try to improve the mechanization technological aspirations in the agriculture sector, right? And finally, we must be doing more and more funding and skilling operations for the people, for the various laborers, for the various informal sectors to actually take new bank loans, take loans under priority sector lending, and be entrepreneurs, right? Also, we understand that recently the government has actually taken many initiatives such as universal account number for various provident fund holders for giving social security benefits to the various unorganized sector in the country. Also, the Shram Suvidha portal facilitates online compliance of labor laws of various MSMEs to actually redress the complaints and disputes of the various labor. Also, labor inspection scheme is there, which is actually talking about labor inclusive say inspection of various units and various establishments. We have other initiatives such as ITI brand ambassadors, appre-sentence say schemes, which is looking into the skilling ecosystem of the country. So these are all the things that we must be doing. due to the increasing number, or say the high number of informal sector employees in the country. In the next article, we'll be looking into the reasons behind heavy rains in India, because at least 80% of the country last week reported widespread rainfall, and right now, as we see right now, many parts of the countries are actually flooded, inundated with excess rainfall. Especially if you look at the state of Kerala right now, there have been many rainfall related deaths in the country. This is a very important aspect for UPSC prelims, for your Indian geography and world geography, and also for GS1, which will look into the various important geophysical phenomena of the country and also of the world. Firstly, we must be looking into the basics of monsoon in a very brief way. Firstly, we understand that the monsoon in India is actually facilitated due to many factors. Firstly, due to the summer conditions, right? We have the various south trade winds that cross the equators, and that actually cross the equator and move towards the Indian landmass due to Coriolis force, Coriolis force. And also we understand that there is this ITCZ, right, intertropical convergence zone, which is actually a zone of very high amount of low pressure. This low pressure is trying to attract the moisture laden winds, right, which is actually crossing the equator and entering India, right, and it is actually carrying a lot of moisture, and that is why we also have this name of southwest monsoon, because the direction is actually from the southwest part. And here we have to understand that during summers the land is actually very hot and very humid, right? So actually what happens, the creation of low pressure that is along this ITCZ line moves beyond the Himalayas into the Tibetan zone. So this is actually creating a zone of very low pressure where the land is very hot during the summers, and this is actually creating a lot of scope of attraction of the high pressure wind zone, right? So where the high the winds from the high pressure zones, they actually flow into India carrying the moisture, and this results in the monsoonal region, or say the monsoonal effect in these many countries, these many parts of the world. Particularly this is seen most significantly in India. Apart from that, please do remember this monsoon climate is also seen in various parts of Africa, in Pakistan, in China, in some southern parts of China, and also in some portions of Southeast Asia and Australia, right? So this was the mechanism monsoon, and we have to right now see what are the main factors that is causing such widespread amount of rainfall. It has been actually predicted back in 1 month only, that this monsoon will be actually an above normal monsoon due to various factors. Firstly, the moisture laden strong westerly winds are coming from the Arabian Sea, right? So firstly, the winds are actually laden with moisture due to high temperature and humid conditions. Secondly, the position of the monsoon trough. Now, trough is actually a low pressure region, which is a semi-permanent low pressure region, which is located right now between Pakistan and Bay of Bengal. So this low pressure region is actually attracting a lot of rainfall, especially in the peninsular, in the central part of the country, right? And also there is another low pressure region, or say offshore trough, on the off the coast of Gujarat and Maharashtra, which is also actually a zone of low pressure, which is leading into lots of rainfall along the coastal regions. For the last 1 week, this trough is there. That is also along the coastal regions of the country, particularly along the western coast of the country. There is a lot of rainfall that is being seen. Also, there is intermittent development of wind shear zone, where this wind shear zone is actually a zone of many various winds of various velocities. Now this wind shear zone is located along latitude 20 degrees north. So this is actually also contributing to a lot of amount of rains right now. And finally, the low pressure system has developed over the west central Bay of Bengal of the Odisha coast here. So this is also creating a high amount of low pressure, which is actually attracting a huge amount of moisture laden westerly winds. So this is actually right now, on Monday this week, it was on the Odisha coast. It has moved on to Chhattisgarh increasingly, and right now it is also moving into parts of Madhya Pradesh. So apart from the offshore trough, and also the trough which is present from Pakistan to this Bay of Bengal, right, to this Bay of Bengal. So this entire low pressure regions is attracting a lot of wind, lot of moisture laden wind, and this is actually leading to widespread rainfall in the country as of now. So these are some of the important reasons which you can attribute. And also finally, the most important reason is the aspect of climate change, because of rising temperatures, rising precipitation, rising instances of thunderstorms. So these rainfall incidents are becoming more and more frequent. So please do not forget to mention this climate change aspect in your answers too. Now for you all, I have another PYQ, 2012 PYQ, the answers of which I definitely want in the comment section, right? Do let me know what do you think of this answer in the comments. In the last part, we'll be looking into the various prelim snippets. We'll be starting with UWin portal, which is actually a digital portal, digital platform looking into integrating the 0 to 5 age group of children on the vaccine portal of the country. So this is actually conceptualized with a target of reducing the number of zero dose children or children who have not received any dose between 0 to 5 years, which is the dose of vaccination, which is actually to prevent the various infectious and the various communicable diseases in young children. So this is actually the target, having the target of halving the prevalence of those zero dose children, and the main target is halving them by 2030. Again, important points for your mains and prelims. Now this is also having the record of the health centers where the people can actually take their children to get vaccinated, and also the various community health workers, right? This is actually to ensure 100% immunization against all kind of diseases, which is actually between 0 to 5 age group, approved by the government of India, right? This will be also facilitating tracking of pregnant women, newborns and adolescents for vaccinations. So community workers, they can themselves voluntarily go to those people who have the potential of being vaccinated. So these are the various activities. Firstly, digitization of routine immunization programs, registration of beneficiaries on the portal, the unified digital portal. Then beneficiaries are also validated using Aadhaar, and a unique ID is created for them, and also the acknowledgement will be sent after every dosage to the parents of the children, right? And here the government will be also engaging the private sector in the future, right, when this particular thing will be actually very prevalent and popular, right? And obviously it will be also linked to the various state governments pregnancy infant cohort monitoring system, and also finally the session vaccinator wise identification of dropouts or left out people can also be tracked easily. So this is a very innovative and a very important portal for the vaccination aspirations of the country. In the next article, we'll be looking into the PM Pradhan Mantri Gram Sadak Yojana. It was launched in 2000 year, December 25th. Initially, it was 100% contributed by the central government. The implementation agency is the Ministry of Rural Development, and here the main objective is to provide all-weather road connectivity. The main news right now in this article is that recently the government will be approving the fourth phase of the Gram Sadak Yojana. The eligibility is firstly ensuring roads to those unconnected inhabitations which are having a population size of around 500 plus in plain areas and 250 plus in northeastern states, Himalayan states and the tribal areas as per 2001 census. Now, it will be also ensuring a core network, that is, that area must be having a minimum network of roads for various economic and various transportation purposes. And in this fourth phase, the government is trying to promote or say increase the prevalence of the motorable roads to 250 plus in the plains, or 250 plus people in the plains and 100 plus people in the special category states. The phases, first phase was implemented in 2000 when connected, all of the unconnected inhabitations were actually connected using this particular scheme. The phase 2 was launched in 2013 when existing rural roads were upgraded. Then finally a very important scheme known as the Road Connectivity Project for Left-Wing Extremism Affected Areas in 2016 was launched to actually build motorable roads in the LW affected areas. And finally the third phase was inaugurated in 2019 where Gramin agricultural markets were focused, high secondary schools, hospitals and consolidation of the lastly constructed roads were actually also focused on. In the next article, we will be looking into the recent CB proposal of setting up new asset classes. Now, what are new asset classes? Firstly, we have to understand these asset classes will be new financial products, right? These are new financial products just like the mutual funds that we have, but it will be actually much more broader than the mutual funds and actually will be much less complicated than the portfolio management services. Now portfolio management services are actually for very high net worth individuals who have a particularly dedicated agency, a private company, an asset management company, right, for various stock performance, stock picking, various entry, exit of stocks, lock-in period, minimum investment, statute, fees, and so on. So these are very big companies who actually manages high net worth individuals. So right now SEBI is proposing, let us bring this portfolio management services, a combination of that and a combination of mutual funds and something between it, right? This is actually known as new asset class. So the minimum investment will be 10 lakh rupees per investor. This is the minimum. And the features is that firstly it will be having regulation by the SEBI. All of the financial products will be particularly regulated. So all the stocks, all the mutual funds, all the government bonds which are invested here, they will be properly regulated. And it will be having some high risk because of the high investment capabilities, and also a mixture of SIP, SWP, STP, or say a systematic investment plan, systematic withdrawal plan, systematic transfer plans, which are available in under mutual fund. They will be there. Investment strategies will be long short equity, or where there will long term and short term equities, or say stocks of companies will be there. There will be also equity related investments, and also say various inverse ETF instruments where the opposite, or say the main criteria of the exchange traded funds in inverse markets, they will be also done. The main eligibility criteria for asset management companies to participate in a new asset class will be, say, the companies which have assets under management of more than 10,000 crores for management of 3 years plus, and they should not be having any regulation issue with SEBI. Or if an company is not having this criteria, second is that they must be having a chief investment officer, or a particular management authority must be having an experience of managing huge amount of funds, right, for this particular new class asset. In the last article, we'll be looking into Indo-Pacific Framework for Prosperity. Now this is not a free trade agreement. It is actually having 4 pillars such as trade, supply chains, clean economy, and fair economy, right? So the main objective of this particular grouping is to enhance resilience, sustainability, inclusiveness, and competitiveness in the region. And the members together, they have 40% of the entire global GDP. The members, firstly, India has partly opted out. India is still not fully a member of the IPF. Apart from this, we have Japan, South Korea, US. We have Australia, Fiji, New Zealand, Brunei, Indonesia, Malaysia, Philippines, Singapore, Thailand, Vietnam, the ASEAN member states. So these are all the countries which are under this. And India right now is actually talking about fully becoming a part of this IPF by actually opting in right now in the trade pillar. We have to see finally what happens, but this is actually a very, very important aspect for your IR and also for your Indian economy. So with this, I thank you all for being very patient, and please do follow the quiz, attempt the quiz which is following up right now. All the best for your preparations. We'll be meeting again. Thank you.